I don't know how much to go into. I was supposed to talk about what states are doing about the law in outer space exploration and mining, and there's so little being done, and I think there's so little of substance to talk about in terms of actual laws. I'm going to talk a little bit about them, but the thrust of what I want to say is that I don't think law is a barrier to exploration, but the prospect of bad law should be kept in mind. And I think it's come up in all of the presentations already. My fundamental point, takeaway, is that law is reactive. And so if you have in mind some ideal space law that you would like to have apply to the space mining industry, think about what events might cause a reaction in a legislative body to produce rules that you don't like, and then try to avoid those events. And I think that would be more thoughtful than most industries have been about developing new rules. So the pieces of legislation that we have on the books today in the world, national legislation about space mining, are largely trying to do two things. They're trying to say to the world community, we, the state of Luxembourg, the United States of America, are not violating our international commitments, because before states did anything, there were these big international treaties about space exploration. And also they are trying to say to domestic actors, don't worry about this international law business. It's not going to get in the way. Continue apace. So let me say a word about international law, and then we can talk about the domestic laws, and then really what I think the action is, the non-law mechanisms, the self-regulation and industry norms that might meaningfully guide this industry if it exists. Okay, so the Moon Treaty, which you've already heard a little bit about, it would be a serious barrier to space mining if it were a thing, but it is essentially a failed treaty. Not a single spacefaring nation has ratified it. The closest is India, which signed it in 1982 but never ended up ratifying it. So for international law purposes, it's non-binding on India. The reason it would be scary for the mining industry is Article 11, which says that neither the surface nor the subsurface of the moon, nor any part thereof or natural resources in place shall become property of any state. That part's not such a big deal, but national organization or non-governmental entity or any natural person. So no mining of space stuff, which is obviously a problem if you anticipate building a business around the mining of space stuff. But it doesn't matter, because the treaty almost doesn't exist except for rhetorical purposes. The Outer Space Treaty is a completely different story. It's been described as the charter of space law. I've heard people describe it as the constitution of international space law. It binds 107 nations, all of the major spacefaring powers, including those with serious ambitions at becoming space powers. It is primarily aimed at nation states, and it was drafted in a very different geopolitical context from the one we live in today, the Cold War era, with an principal aim of avoiding the militarization and colonization of the moon and other spaces. And it says that space is the province of all mankind, which is a vague statement that some have read to, I think wrongly, have read to think means that this treaty somehow is inconsistent with space mining, but I just don't see any evidence for that. So I'm going to quickly go through some of the articles of the Outer Space Treaty, because I just want to be clear. I don't think that any justifiable reading, international law reading of this treaty can be seen as somehow a problem for space mining. Article 1 says, exploration shall be carried out for the benefit and the interests of all countries and shall be the province of all mankind. Article 2, outer space, including the moon and other celestial bodies, is not subject to national appropriation by claim of sovereignty, by means or of use or occupation, or by other means. Okay, so the concern here, if you were a mining company, is your operation somehow connected to a national claim of sovereignty? And unless you were doing the kind of mining that some Chinese commercial entities have done in the South China Sea that are in connection with attempts to aggrandize China's claims of territorial sovereignty, unless that's the kind of mining activity you have in mind in outer space, working with NASA in order to enlarge some kind of territorial sovereignty claim that the United States government is making, I don't see this article as being a problem for outer space mining activities.
What about the occupation? The following phrase says by means of occupation.
Well, it's aimed at a nation state. So again, what's the concern for Freeport to head to the moon under license from the United States government to do exploration and mining? The only way you would come into trouble, in my view, justifiable legal trouble vis-a-vis the Outer Space Treaty is if your activities are seen as nation-state activities, so you're a state actor, and you are acting in order to appropriate a claim of sovereignty.
How do you justify the company town?
What's that?
How would you justify the company town? If Freeport goes up and puts a company town down in order to support a mine, wouldn't that be considered aggrandizing as of yet nation state? But the nation state is supported in the free market.
That's not the way that company towns have been viewed in any other context. So a company town is there to support the company, but it is not a furtherance. It's not flying under the flag of and attempting to expand the sovereignty of the flag they're flying under.
But that's because all company towns have been already under a different government. Like all company towns in California were always just already in California, which was already its own state.
Not always. There are company towns so Freeport runs, let's say, a company town in a country that's not the United States where they're exploring, they're working a mine. And they're not claiming sovereignty over that nation state.
Because that state is already a country. That place is already under a different country.
Right. So are you saying then this is helpful because we're working through, we are going to, and I say we as law students, as lawyers, but courts are going to resolve disputes someday about fights over claims and natural resources, and maybe there will be a question about interpreting the text of this treaty. So reasoning by analogy, then, from what you've just said, I think you're suggesting then that a Nautilus, when they work a mine out in the deep seabed, out in space, they are asserting a territorial national sovereignty claim over that piece of the ocean. I don't think that's defensible. And that's the way the space exploration would be viewed. Yeah.
Does anything in the existing legislation require that Freeport get a license from a sovereign nation to do something?
It's Article 6.
Yeah.
You get a license, but that doesn't mean that the nation is asserting sovereignty.
Yeah, so let me finish the presentation on treaties, and then I'll get to state activities, and then we can talk about how the whole thing's supposed to work. So Article 6 of the Outer Space Treaty says, states parties are responsible for national activities in outer space, right? You want to allow exploration, non-governmental activities, or governmental activities. You have to be responsible about it. Again, it's pretty vague language. The key piece here is state, and the key focus at the time was who's going to be responsible for when things go wrong, and the answer is the state that sponsors the activity. And non-governmental activities must be authorized and supervised by the relevant nation state. So some authority has to certify that the state is responsible for whatever happens as a consequence of the exploration. But how that gets worked out and where the liability is distributed between the state and the non-state entity that's sending the rocket into space is left up to the state to figure out as a matter of national law or even just contract.
Yeah, the implication, I think, is that national legal regimes would apply to a licensed entity. The activities of a licensed entity does not, again, imply that the nation state has asserted sovereignty.
Well, I don't think it has anything to do with sovereignty. It's just saying states are responsible for the activities that they authorize.
If somebody is killed, then the nation state that licenses it is responsible for dealing with that crime.
Right, but which has to do with responsibility, but not with sovereignty.
Exactly.
And just, I hate to keep it around, but you actually had a violation of Article 6 earlier this year with the satellite company launching satellites without a license.
Yeah.
And they were hauled up and fined for it. So it's like, bad one.
But what was the fine? What was the?
It wasn't much. It was hundreds of thousands of dollars. It wasn't enough to prevent anybody from doing it, but it was enough to establish that, yes, there is a way that, in this case, FAA supervising authority, FAA could fine them for not following the rules.
And what was the authority that they were, it wasn't Article 6, right? Article 6 would just be, we could hold this out as an example to the world to say the United States takes seriously its Article 6 commitments, but it wasn't, when the fine comes across the transom, you get an email saying, hey, you're being fined. It's not under Article 6. So what was the domestic authority for the fine? What rule did they break?
I think it was supervision, because it was.
It's under the FAA's responsibility for supervising launches.
And I got it wrong. It wasn't that, it was FCC.
That's what I thought,
FCC.
Did I say?
I said FAA and I was wrong. FCC.
Yeah.
They were launching satellites that were too small to be tracked, and FCC said they couldn't do it. They launched anyhow.
Okay, but in violation of FCC regulations.
But I think the FCC regs trace back to Article 6.
Right. That might be right. I'm just saying as a matter of domestic law, which is developed as a part of our international responsibilities.
Because there's some things State Department supervises, some things NOAA supervises. Different agencies have developed that authority. Yeah.
So the international law reading of this treaty that leads me to believe that outer space activities by an American mining company, let's say, are not claims of sovereignty is that Article 6, which explicitly refers to private entities, underscores the fact that Article 2 doesn't. Okay? So Article 2, again, which has this concern about national appropriation and sovereignty, is directly aimed at states and not private entities. And I think that point is underscored by the fact that later in the treaty there's discussion of private entities. So if the drafters had been concerned with claims of national sovereignty by private entities, the company town type thing, that could have been drafted and included in Part 2, in Article 2, but it wasn't. And it's not like they just forgot about private entities because they included them in Article 6. Okay, and then some people think there's an ambiguity about Article 6 referring to national activities as being both private and public. But again, the ambiguity there would be limited to Article 6 under a standard reading of the treaty.
Well, I'm not sure there's an ambiguity because nations are required to be responsible for their private entities.
Yeah, well,
so that would be national activities.
I'm not sure. I think that there is a debate about there being an ambiguity. Okay, so there are two sides of that debate. You fall on one side, but here's how the argument goes. Under Article 6, state parties are responsible for national activities. What is a national activity? It includes both NASA activities, but also private entities that are authorized. Okay, correct. So some people have made the argument that because they say national activities includes private activities, that elsewhere in the treaty, like in Article 2, where there's a reference to national conduct, that must also include private activity. I don't find it convincing because, again, they didn't articulate any specific reference to private activity in Article 2 like they did in Article 6, but that's the argument. This is what gives the Europeans concern about the Outer Space Treaty. But there is, again, no space-faring nation, maybe also space-fearing nation, that takes this interpretation. Okay. So if outer space, if international law isn't a prohibition, what do national laws say? There are essentially two. There are a couple others in the works, but there are two that have been developed and implemented: America's and Luxembourg's. The U.S. Commercial Space Launch Competitiveness Act, which is referred to sometimes as the Space Act, says, a United States citizen engaged in commercial recovery of an asteroid resource or a space resource under this chapter shall be entitled to any asteroid resource or space resource obtained, including to possess, own, transport, use, and sell the asteroid resource or space resource obtained in accordance with applicable law, including the international obligations of the United States. Now, the way I read this is largely telling the international community, this is how we interpret the Outer Space Treaty as not prohibiting private space activities, and then, turning to the private space industry in the United States, carry on. It's not creating new rights. It's clarifying long-standing common law rights of capture as applied to outer space. Okay. Luxembourg has a similar, slightly different, but very similar take on this. Draft law on the exploration of use of space resources, which passed just a few years later. European companies with an office in Luxembourg can extract space resources for commercial use. There's similarly a requirement of prior government approval. There are criminal penalties for space mining without approval, and applications for governmental approval are judged based on ties to Luxembourg. So there's a little local favoritism there. The seriousness of the implementation plan and the governance scheme. So this was a smart move on Luxembourg's part to invite a bunch of new offices to be opened up in Luxembourg, which in fact happened. Separate from space law, that's it for domestic space law. Okay, and then separate from space law, there's quite a bit of space practice, including very high-level government statements about space practice. So you've got ministers at nearly the highest levels in China and India saying things like, we believe that our national policy is essentially what the American Space Act says, which is to say international law is not a bar, and we believe in the law of capture, and we should get going. And by the way, because Luxembourg has crafted the regime that they've crafted, they've entered into bilateral agreements with other countries who don't yet have domestic statutory arrangements, which is quite similar to the way that non-deep sea bed mining countries have structured bilateral agreements to allow licensing under the ISA of deep sea resources. So Japan and Luxembourg have a 5-year agreement. Portugal and the UAE have similar deals. And they've poured quite a bit of money into Luxembourg as a consequence. China and Russia initially made a bit of noise about US intentions to conduct mining in space, but they have largely dropped those concerns and are now poised to join the fund. I think another way to phrase that is they were always poised to join in on the fund, but they were making a lot of noise about it being wrong, and there's much less noise being made now. The United Arab Emirates has for a couple of years now been really serious about a space policy program, including a national space policy, and proposed laws have been kicked around. There was a law introduced in the UAE's legislature earlier this year, but I don't think it's been signed into law. Do you know?
I was looking this up for this meeting.
Yeah.
It passed their legislature, but has not yet been signed.
That's what I thought.
I don't know why.
Yeah, that's what I thought too. And the one thing that I've noticed that's strikingly similar across the board is that these two features that I've described about America and Luxembourg's laws seem to be consistently repeated in the government statements by major seafaring nations, with spacefaring nations, which is essentially finders keepers to domestic industries, go out and get it. And to the international community, we don't think our signature in the Outer Space Treaty is a real barrier. So there will be, changes at the margins, differences at the margins between different regimes. But I think for the most part, there's a race on to get to just clarify that domestic industry can get moving. So what do we do, right? What do you do if you're a company that wants to do space mining or your planetary resources, and you don't think international law is a barrier, and in fact, to the contrary, you've got domestic green lighting? Does that mean you send your rockets into space and not really worry? I hope that presentations that we've heard today about mining, the history of mining in terrestrial mining, and also the deep sea stories are useful precautionary tales, right? Where there are no rules, so you should develop your own, basically. So there's a long history of self-regulation in different industries, and self-regulation gets a bad rap. It's often described as an cynical attempt to try to preempt and prevent actual legislation. But there are plenty of examples where it's a race to the top, in addition to just being a race or in contrast to being a race to the bottom. So as one example, the Central Valley Growers Authority in California decided that they were fearful of having USDA come and do very expensive and rigorous, onerous regulations. And so they developed a bunch of safe growing practices, basically self-monitoring and self-enforced, but self-developed and quite sensible. So when the Food Safety Modernization Act happened, Congress got to looking into it and said, wow, actually industry standards here are really good. And we don't need to step in or alter any of the rules. We just need to step up, institute an enforcement mechanism. But the industry essentially got to write its own rules with the stamp of approval by government, and without the concern that the rules were being made in a way that, just for window dressing without any actual enforcement authority. Now they actually have enforcement authority. So if you're excited about space mining, and you're excited to hear that there is no barrier to seeking and capturing space resources, I don't think that means you should fire your lawyers and go home or just go work on rockets. I think it means we should think seriously about what kinds of rules the industry as a whole should develop in a way to try to establish basic norms so that later you can identify bad actors who are not complying with what the industry norm is, and also you can preempt concerns that the industry has developed without any concern for externalities. Something I hope we can talk about in the conversation to come. But I think I'll stop there, and I'm excited to take your questions if you have any.